Hello, ladies and gentlemen. My name is Grażyna Górska. I'm a mediator and vice president of the Association of Civil Mediators. I'd like to welcome all of the participants of the Nowy Tomyśl conference, as well as its organizers, whom I'd like to thank for extending an invitation to join in the discussion and to share my expertise, as well as to voice my opinion on whether the current situation will lead to an upturn in the use of alternative dispute-solving methodologies. To answer this question, I think it will. I think this time will be conducive to new alternatives to in-court proceedings, because we will be in a dire need of quick and agile solutions. As a mediator, I have observed firsthand a steady growth of mediation cases, mostly family-related, commercial and civil cases, as well as more and more labor mediations. This goes to show us that courts perceive mediations as favorable, as do parties, which is only positive. In my talk, I'd like to focus on contractual mediations, or pre-trial mediations, in which the parties consciously and voluntarily engage in amicable disputes. I think that under the current situation of the economic crisis and the pandemic, I think contractual mediations provide the parties with the greatest opportunities and benefits. I have pointed to several factors that I consider vital to the use of this particular method of dispute solving. The first one is time. Time is money, as the old adage goes. We know that any unresolved settlement generates losses. Cases dragging months and months on end, if not years and years on end, translates into suspended contracts and unimplemented procedures. So time is of the essence. We need to be quick in terms of decision making. We need to act here and now. We cannot allow ourselves the luxury of waiting for a year or two, if not 5, until the court rules in our favor. We need rapid fire solutions. So the time factor under the current circumstances is absolutely vital. Contractual mediations enable parties to reach settlement before a mediator that will later on be validated by a court of law in a closed-door hearing. As per my experience, it usually takes about a month before a dispute is validated by the court. Therefore, the resolution comes very quickly. Under the current circumstances, therefore, it is a great solution time-wise. Another factor that is crucial is avoiding uncertainty. The parties must be sure as to how the case will be resolved. We live in a time of great uncertainty indeed. And hence, we need solutions that will provide us with decisive answers, that will tell us how the situation looks like, what we can do without overthinking it. We will know when our case will be resolved and how it will be resolved and who will be the beneficiary. Equally important is the matter of finances, court fees and court proceedings fees. All of that indicates that mediation is the cheapest way of dispute solving, which is again beneficial under the pandemic circumstances. However, I'd like to talk about something else right now, namely the need of maintaining business contacts. Mediations enable us to clear the air, enable the parties to jointly look for solutions and to give themselves a chance at prolonging their collaboration, because as it may happen under the crisis, it is our contractors, our business partners, our workers today that will be absolutely vital to our success. So let us give ourselves a chance to continue collaboration, because it will be beneficial to both parties. Another factor is the so-called peace of mind. Whenever I engage in conversations with my clients, I ask them about what conflict means to their professional and private life, both at home and at their office. They tell me that it often involves stress and uncertainty as to the future. And right here, it is where we step in to provide our clients with peace of mind, to give them a sense of closure, and to move forward. Yet another aspect that I'd like to touch upon is conflict escalation. We need to do our best in order to de-escalate, to prevent parties from engaging in actions that are not aimed at resolving the conflict, but are targeted against the other party. One phenomenon that explains that very clearly is the so-called glasswall staircase, which shows us that the parties often engage in actions that move them towards a dangerous ground. As per Glasswall, the whole cycle begins with tension with regard to adopted positions, followed by debate and polemics, followed by actions instead of words. These three constitute the first stage, followed by the second stage, which is coalition building, followed by the very dangerous phase of loss of face and threats instead of words. The third and final stage is the most dangerous one, and it involves limited destruction, total annihilation, and together in the abyss, namely the situation in which both parties end up lacerated, wounded, and at a loss. They both hit rock bottom. Therefore, we need to intervene, step in before parties engage in self-destructive behaviors. This is absolutely essential, and it needs to be done as soon as possible. And this is where we return to contractual mediations. Obviously, the similar results can be achieved through court mediations, but only provided that court mediations begin immediately, promptly after the case is assigned for mediation, before the parties begin to engage in dangerous behaviors. We know that the timeline between the beginning of the conflict and bringing in an action against somebody is that of several months, if not years. Therefore, it is substantial. And hence, court mediation, if it's swift, if it's immediate, it has the greatest chance of success. I'd like to wish myself and you, ladies and gentlemen, to be able to draw conclusions from the current circumstances and to reforge them into opportunities. I say so because I hope that, considering the criteria of time, costs, and quick, flexible solutions, thinking outside of the box, traditional solutions might prove insufficient, because debtors will be unable to pay back their debts because they face financial dire straits and they don't know if they will be afloat in a year or two. And hence we need to look for solutions jointly with all the parties involved, always having the current situation at the back of our head. Thanking you all for your attention. I hope in a year we will be able to sum up the current reality and how it translated into the number of mediations, both in court and out of court contractual mediations. Thank you very much. Hello. Thank you for inviting me to the annual conference organized by the Court of Arbitration of the Nowy Tomyśl Chamber of Commerce themed Arbitration and Mediation. This year's edition is special because it's an online one. My name is Paweł Krzywda and I'm a lawyer by profession, but by trade I deal with mediations. I am a mediator listed with the district courts of Poznań and Szczecin. The coronavirus pandemic has proven how quickly the world is changing. I experienced it firsthand because a year ago I used to live here in Nowy Tomyśl, where I taught as a young mediator to the students of the School of Law and Administration, where I acted as a lecturer on commercial arbitration and mediation. In the meantime, I completed another year of my preparatory program as attorney at law at the city attorney's offices in Poznań and Szczecin, and I established collaboration with an international law firm and moved to Świnoujście, where I first worked at the local court as a judge assistant, and right now I lead a legal assistance center. I remain in touch with my former employees in Poznań, Nowy Tomyśl, and nationwide. So, generally speaking, until the coronavirus strikes the internet itself, my professional life will not be radically changed, and I will keep supporting parties in terms of resolving business and family-related disputes. Today is my debut as a online lecturer, so I will be glad for any feedback from your side. This year's theme, arbitration and mediation, prompted me to touch upon the potential difficulties related to mediations in the time of the coronavirus pandemic. Depending on whether you're a rookie mediator or an experienced one, you can draw different conclusions, which is only natural in this case. The coronavirus pandemic has no doubt changed the world, so new challenges and new requirements are faced by mediators too. Due to my today's time constraints, I will focus on three main points that are vital in this regard. First of all, the market itself, how to procure your clients while maintaining social distancing standards and with most courts locked down. The second issue is technology in the service of communication, i.e. major and minor problems related to technology. 3. The fear of the unknown, anxieties of the parties involved in terms of the new way of communicating, fears related to security, confidentiality, or a general sense of anxiety. I specialize in resolving commercial disputes online, but the time of the pandemic has nonetheless impacted me. I had to put several ideas on hold in terms of alternative methods of resolving these disputes. I also tried to expand my scope of services to include transnational commercial disputes in Germany. With commercial disputes, I find myself best suited to act as a lawyer in this profession because I have constantly improved my competences at the city's attorney's offices in Poznań and Szczecin, so it is all the more easier for me to understand the specificity of these problems, and therefore I can adjust on the fly to accommodate my clients and to provide them with a broader perspective and share stories of those clients of mine who failed to use amicable solutions and ended up in court, oftentimes to no avail. Today I wanted to share my know-how and a few observations on the mediation market in the time of the pandemic. With regard to the three difficulties, I will focus on remote mediation because in the time of the pandemic, any alternative forms of conducting meetings is a risky one. While operating remotely, you do it risk-free, and you can communicate from every corner of the globe while maintaining standards of security and confidentiality, while maintaining top quality services. What is more, as this very time has taught us all, we are able to reach out to customers who are far removed from one another, which is nothing new because prior to the pandemic, remote meetings had been organized out of convenience, while today they are held out of necessity. However, I was supposed to talk about difficulties rather than opportunities, so normally speaking, while I was here speaking live, this gave me a chance to engage in a Q&A with my live audience, different sorts of entrepreneurs with different problems and different observations. So I am all the more curious how other mediators at this time have dealt with problems and hardships, whether they procured new commissions or whether they put their businesses on hold. I reached out to a couple of my mediator colleagues, inquiring about these difficulties with mediation during the time of the pandemic. Having analyzed their answers, I focused on three main points. First of all, technical issues, lack of proper software or instruments facilitating online mediation, even as simple facilities as your headset and the mic, which if you hadn't used it because you were used to conducting mediations face-to-face back in your office, you had to do so. The rapid spread of the pandemic has took us all by surprise, most of all those that were operating on a face-to-face basis prior to the pandemic and did not use any facilities or software. One way to overcome this hurdle is pretty easy. It is your phone. A regular cell phone with a camera, which does not require any complicated software. So it's an all-in-one device which you can use to communicate with many people at the same time in a multilateral call. You can easily verify their identity by asking them to present their ID in front of the camera. When it comes to confidentiality and recordings, you can use different sorts of software for that purpose, which will preclude the very possibility of illegal recording. And if somebody wanted to record you in a clandestine fashion, you can preclude that opportunity as well by asking them to use earphones only, which will eliminate the possibility of recording anything other than their own speech. Out of the available software, my recommendations would include Zoom, WhatsApp, Skype, recently, so also Facebook and Google, which have enabled registered users to use such solutions free of charge. The second point included fears and anxieties of this remote mediation, as well as online exclusion. These fears are commonplace and encountered by many who fear having their speech or utterances recorded and used against them in the future. Those people might also fear not being properly heard. Depending on the entities in terms of commercial disputes, no such technical hardships are to be feared, but there is an issue with confidentiality and security, which can be overcome, as I've said, by appropriate software and encrypted connections. Unfortunately, Zoom does not offer encrypted connection I think that Skype or an ICT network, an in-house ICT network, can offer solutions in this regard and provide you with secure connections. When it comes to other parties in disputes, I think that the current time of the coronavirus pandemic prompts us to recognize such fears of any parties who are reluctant to conduct remote mediations. Mediation is voluntary, so I have to persuade them in the first place to engage in a conversation. And for the sake of their psychological comfort, I think we should recognize their need of security and perhaps consider suspending the mediations or use a regular phone call as your means of communication, which will certify and verify the identity of every speaker by their voice only. Third of all, the market of commission and the lockdown of courts, which prohibited us all from peeking into files. Right now, many courts have reopened, but depending on your experience and track record on the market as a mediator, the lockdown of courts that was the case might have drastically limited the number of cases assigned to you. So in view of that, you have to stay proactive and use new channels of commissions. The market is changing, so let's be active online. Let's use many counseling groups in terms of legal counseling associations, which have often recognized our status as mediators, offering legal assistance. So let's actively look for opportunities and chances online. I know that I have gone over my time limit, so without further ado, let me conclude by saying that my advice to you is let's act, let's strike iron while it's hot. We have a chance to use online mediation as an unprecedented way of resolving disputes. A successful person is who acts quickly and adjusts on the fly. So if you have encountered any of these hardships in the past few months, I hope I have encouraged you to overcome them successfully. However, if your case is that of any other problem, don't hesitate to contact me at mediator.krzywda@gmail.com and I'll do my best to help you out. Some of us like to be successful, others prefer to make excuses. If you are into communication and resolving business or family-related disputes, let's stay in touch, and no coronavirus pandemic will give us a scare.
Good morning. My name is Nina Tereshchenko. I'm a mediator from Ukraine, from the Odessa District Mediation Group, and a board member of the Ukrainian Mediators Association. Thank you for inviting me to this conference this year. From this distinguished group of mediators, I have followed your event for a long time, and I'm glad that this time I'm able to join you. I was thinking about what could be interesting to share with you, such distinguished mediators, and I will focus on two factors. On the one hand, in Ukraine, we celebrated Mediation Year to mark the 25th anniversary of mediation in Ukraine. 25 years is a long time, actually, when you can summarize a number of achievements that the first organizations that dealt with mediation institutional mediation sprang up in Ukraine 25 years ago. As to the development of mediation and the status of mediation today, it's something already established in Ukraine. What can be interesting for mediators from post-Soviet countries, I believe that mediation after the reform period is interesting because actually the problems that we deal with are universal. I began work as a mediator in 2014, and the year 2014 is a breakthrough year because this is the political crisis, this is the Maidan in Kiev, this is the war, and big divisions within the society. Mediators responded to those challenges, and a big group of mediators, myself included, started to be engaged in dialogue. We conducted a number of events to lower the tension between social groups. In Odessa, we organized this Odessa model of dialogue. Now, what is the difference between dialogue as a process from mediation? First of all, unlike mediators, those who facilitate dialogue have a particular position towards the conflict. And this is really very important. One of the tasks of dialogue is to facilitate communication or to lower the polarization between different parties. And this is one other distinguishing feature of dialogue. Thanks to the efforts of international organizations that also appeared in Odessa in 2014 and 15, and thanks to the efforts of the mediators who'd already begun dialogue, we actually managed to educate a large group of people to conduct and facilitate dialogue. In 2016 and 17, we had a group that believed that certain standards should be adopted for dialogue, for its process, for its outcomes, what kind of skill set is required. Over the past 2 years, dialogue has developed so much in Ukraine and has resonated so widely, has been led as encounters, as meetings, as long procedures. Also, with the use of a number of different factors. And in 2020, we finally had to answer in more unequivocal terms what is the difference between mediation and dialogue. We have not resolved the case, but there are a number of distinguishing features between the two. Why should we distinguish between these two? First of all, dialogue and mediation have different purposes. This is not always clear, but this does work, and this is pretty evident. And maybe that is why dialogue has become very popular, if not fashionable, when we conduct dialogue to resolve a dispute. Well, the person who facilitates dialogue does not have the competences of the mediator, and the other way around. Actually, those dialogue facilitators and mediators have different competences, different skills. We have examples of very popular cases where we invite specialists who may not be able to work in large territorial communities, and mediation is then discredited because the tasks that the mediator was entrusted with were not resolved conclusively, and that is why we need to cooperate. Both mediators and dialogue facilitators need to cooperate, and I believe this is also a task for this coming year, and I believe that within the next 12 or 18 months, mediators and dialogue facilitators are going to redouble efforts to create programs together. What level has dialogue reached, and what is about the reforms? Thanks to the active participation of international organizations such as OSCE as the coordinator of projects, dialogue, you can say, has become quite voguish, both among activists and state authority. And this is something I would like to highlight, because there have been cases that a whole number of ministries related to the reforms are learning what dialogue is. They also mandate dialogue to different authorities. The dialogue facilitators try to reach different solutions to implement reforms. So this is not at a professional level. We are still learning, but this is also a very positive outcome, also for all ADR, mediation included. We also have academic courses for dialogue facilitators. However, these are just the initial attempts. However, I believe that within a foreseeable time, our universities are going to provide classes in conflict resolution, the different techniques, instruments to achieve outcomes in such dispute resolution proceedings. Now, what happens in mediation in Ukraine? Say 25 years we haven't been able to adopt a law. We are now running a campaign, but for different reasons, political reasons, the law hasn't been adopted. And over the past few years, we have really expressed concern that there are groups that would like the mediation law to follow the hierarchy similar to that in the bar of advocates, and this may hamper, if not reverse, the process of introducing mediation in Ukraine. Now, how does mediation develop now? We specialize as mediators. For example, we have family mediators, community mediation, we have ministerial or sectoral mediation, for example, in IT or intellectual property, medicine. This is also a good outcome. When we have specialization, this means that the level of and the quality of services is also higher. We have laws on mediation as a social service. So here we deal with a social sphere, with a state sphere. We are talking here restorative justice, the use of mediation in criminal proceedings. These issues are, you may say, regulated by the state. This is, I would say, a very positive development. The law somehow makes it impossible for us to move forward as fast as we could, but we have to say that thanks to the specialization, the market so far is not fully developed. That is, mediation is an active service, generally entirely acceptable market service. I believe this is a task for the next couple of years, and as soon as the mediation law has been passed by Parliament, I believe that there will be more mediation proceedings. Now, what is the relationship between mediation and reforms? Quite recently, Parliament passed a property law on the sale and purchase of property, and I expect that there might be more disputes concerning property sale and purchase. One of the areas where we have active dialogue and mediation is devolution, is political devolution. We are currently in the process of a reform where within small groups we resolve conflict, and this is the direction that our communities, associations will develop after gaining additional competences, how they are going to plan and develop their territorial communities. The perspectives of mediation are great. There is also dialogue at different levels. There is dialogue within the communities and at the state level, and this is very stable and also a very perspectivist area. And this is, I believe, all I have wanted to share with you, ladies and gentlemen, about the question of mediation in Ukraine and what mediation in Ukraine involves. If you have any further questions, I'm more than willing to answer them. Thank you so much, and goodbye.
Hello, I'm Jolanta Timura. I'm a notary and a mediator in the Mediation Center of the National Notary Association. I would like to talk to you about online mediation, a solution for difficult times or a plan for the future. Currently, the regulations do not determine how a mediator is to provide mediation proceedings. However, we have certain laws which include provisions that a court may refer parties to mediation also via electronic mail or other ways of reaching the parties. Before the pandemic, as a rule, courts issued decisions on referring a case to mediation by registered mail. During the pandemic, using Section 170, courts began to send by email notifications of referral to mediation, including a PDF file on the relevant decision. Also, in our center, we have supplemented our procedure of mediation proceeding with online mediation. We have assumed that mediation can be conducted via direct contact of the mediator with the parties, or through ICT, or through mixed media, by either direct contact and by the ICT media. We have assumed that the referral by the court for mediation can also take the form of a document or electronic means. We have also assumed that a mediator, by getting a referral for mediation by an email and a PDF file, can already commence mediation proceedings. If an email contains contact data of the parties, their phone numbers, the mediator contacts the parties by phone, asking whether such online mediation is feasible and whether the parties have adequate technical means, that is, whether they have access to the internet and phone. If not, then we can, the mediator can send an invitation to mediation and again asks whether online mediation is possible. If when a mediator has already punched out background and has seen that mediation is feasible, they can commence mediation. They notify the parties how mediation can proceed, what platform is going to be used, whether it's going to be Zoom, Microsoft, or other platform, and they also set the date for the meeting. This entails some problems. The first one concerns confidentiality. The mediator does notify the parties about confidentiality principles throughout the mediation proceedings. Still, we are not sure whether this confidentiality is not breached in a room when a party to the mediation proceeding is currently residing. Another problem is the verification of the party's ID. The mediator first introduces him or herself to the parties, and they show to them the ID card, which they show to the camera so that the parties can read the exact contact data, and the mediator asks the parties to do the same, to show their IDs, and to make it clearly visible on the screen. After the mediation procedure is over, we had another issue to grapple with, that is how to sign an agreement online. Our procedure, however, also provides a solution. We have assumed that the mediator simply reads out a draft agreement during the video conference. After this draft agreement has been accepted by the parties, then the mediator sends an email to the parties, and then there are again two avenues of conduct. The first one is when the parties have a qualified digital signature. They sign the document, then they send it over to the mediator. The mediator prepares the final draft, and all of this is sent electronically to the court that referred the case to mediation. If the parties have no access to secure digital signature, the mediator sends the draft document to the parties by email. Then the parties send the draft agreement with their signatures, and the mediator informs the parties that they have received this. If they are a notary themselves, then they draft the final contract, and then they send the final document to the court. Mediation is finished once we have a signed agreement, and the result of the agreement is when the final signature is applied, including the signature of the mediator, him or herself. The draft agreement notifies that has this information that mediation was conducted online, and also we have some rules of conduct during such a procedure. Now, what have been some of the problems we have dealt with? For example, we've had technical problems. The mediator has a dilemma whether to return to a meeting when all of a sudden somebody has lost the connection, or whether to set up a new date. Another issue was access to a laptop or a phone. One other issue was the breach of confidentiality. However, we have tried to eliminate all of these problems in our mediation center at the National Association of Notaries Public. However, even though we know about these drawbacks, we have also clear benefits. For example, sick people can take part in these mediation proceedings. Also, this proceeding can be conducted with respect to parties who live in different towns or even different countries. One other benefit of mediation, of online mediation, is that during the pandemic, we have really grown accustomed to do a lot of things online. We work remotely, we learn remotely, and even international conferences like this one are conducted remotely. So, if we have accustomed the parties, obviously showing to them clear, unequivocal procedures about online procedures, these rules will be accepted by both the parties and the courts. Thank you for your attention.